Now I can say welcome. Welcome and thanks to you all for being here. And thanks also to the others that I can't see. We're here to talk about the Supreme Court's decision on affirmative action. And to talk about it partly from an unaccustomed perspective, which is the perspective of international human rights law. The decision of the Supreme Court this summer came as a shock, but not a surprise. Its precise consequences are uncertain and are playing out slowly in the lower courts. And we'd like to talk about what the Supreme Court has done, what international human rights law has to say about this, and why that matters. The Human Rights Program has been lucky to convene a stellar panel of experts, so I will speak as little as possible. In fact, I even forgot to introduce myself. I'm Gerald Newman. I'm the director of the Human Rights Program, which organized this panel. We will talk. We'll have the experts, the true experts, talk about this, which includes 2 speakers in the room and 2 speakers who are joining us remotely. The first speaker will be Professor Guy Auriel Charles, who is the Charles J. Ogletree Jr. Professor of Law here at Harvard Law School, also the director of the Charles Hamilton Houston Institute for Race and Justice. His scholarship focuses on how law mediates political power and how law addresses racial subordination. Professor Charles was appointed by President Joseph Biden to the Presidential Commission on the Supreme Court of the United States before we had this latest input on the behavior of the Supreme Court of the United States. Professor Gay McDougall, who's joining us remotely, is currently a distinguished scholar in residence at the Leitner Center for International Law and Justice and Center for Race Law and Justice at Fordham University Law School. She has, in her long and distinguished career, held such positions as Special Rapporteur to the UN Subcommission on the Prevention of Discrimination and Protection of Minorities, independent expert on minority issues for the UN Human Rights Commission, and member of the UN Committee on the Elimination of Racial Discrimination, the CERD Committee, to which she is currently in her 3rd 4-year term, having been nominated for that body, first by President Clinton, then by President Obama, and then most recently by President Biden. Professor Tendai Achume is the inaugural Alicia Mignana Professor of Law at UCLA Law and former faculty director of the UCLA Law Promise Institute for Human Rights. She's currently Leah Kaplan Visiting Professor in Human Rights at the Stanford Law School and an extraordinary professor in the Department of Jurisprudence at the University of Pretoria in South Africa. She's also a research associate with the African Center for Migration and Society at the University of Witwatersrand, and a research associate with the Refugee Studies Center at the University of Oxford, which is in the United Kingdom. From 2017 to 2022, Professor Achume was the UN Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. And Professor Justin Hansford, who is with us in the room, is Professor of Law at Howard University School of Law, the founding executive director of the Thurgood Marshall Civil Rights Center, and a member of the recently created UN Permanent Forum on People of African Descent. He was previously a Democracy Project Fellow at Harvard University, a visiting professor of law at Georgetown University Law Center, and an associate professor of law at St. Louis University. Professor Hansford is a leading scholar and activist in the areas of critical race theory, human rights, and law and social movements. They will be speaking in the order I've just described for reasons that I think will become clear from the topics that they choose to address. This program today is co-sponsored, and we thank our co-sponsors, including the Harvard Law School Human Rights Clinic, the Charles Hamilton Houston Institute for Race and Justice, and the FXB Center for Health and Human Rights at Harvard University. We will be taking questions from the floor after the panelists have had an opportunity to speak, and I look forward to learning along with you. So without further ado, let me give the word to Professor Charles.
Good afternoon, and thank you, Jerry, and the Human Rights Program. It's great to be on this panel with my friends, Justin, Tendai, and Gay. They're all human rights experts, and you all know way more about human rights than I do. I am here only to begin to present the domestic side. So let me get going along that front. Okay, so the question I think presented by SFFA versus Harvard, there's a question with respect to race consciousness and admissions, and we'll talk about that in a moment. But the fundamental question really is about how to distribute scarce goods, in this case, educational goods, in a divided society stratified by race, class, and history. Right? That's really the fundamental question. And how should we think about the role of law and addressing and mediating those sets of questions? So we have different groups in our society. They have different histories. They have different expressions of privilege and different expressions of oppression. And the rules that we make is going to have an impact on them differently. And the fundamental questions really are, what institutions should we trust to make those types of decisions, and what should those rules really be? All right. Now, in this particular context, what we see is that the Supreme Court deciding that it ought to be the institution that mediates those questions through essentially a formalist interpretation of the Constitution, the 14th Amendment and the Equal Protection Clause as the instrument for mediating those types of questions by the court. So you know what the outcome is. The court struck down Harvard's and UNC's affirmative action program. The court was ideologically divided with the conservatives and an opinion by Roberts for the majority, with the left of center liberals, Kagan, Sotomayor, and Jackson, dissenting opinions by Sotomayor and by Jackson, concurrences by Gorsuch. Thomas writes a concurrence emphasizing that the Constitution is colorblind with respect to race. Gorsuch writes one emphasizing that Title VI is colorblind with respect to race. Kavanaugh writes a concurrence emphasizing that there ought to be a time limit on race-conscious decision-making, and this is it. Sotomayor writes a dissent joined by Kagan and Jackson that provides a sweeping view of the history and necessity of race-conscious decision-making for equality-enhancing purposes. And Jackson writes a dissent joined by Kagan and Sotomayor that is essentially an ode to Black courage in the face of structural oppression for all intents and purposes. Okay, so the holding is that the affirmative action policies of both of those schools violate both Title VI of the Civil Rights Act of '64, as well as the Equal Protection Clause of the 14th Amendment. It's a formalist idea of equality, that equality means that you can't treat people differently, with a very narrow conception of what it means to treat people differently. Roberts argues that the landmark decision of Brown v. Board that essentially ushered out the Jim Crow regime, starting with in the educational context, but much more broadly throughout our society, that landmark decision is the one that determines how to think about the question of race-based affirmative action in higher education, and that the core purpose of the Equal Protection Clause is to do away with all governmentally imposed distinctions based on race. And if you've read Roberts' race opinions, no Roberts race opinion is complete without some form of a silly aphorism. And the one that we get here is a statement that eliminating racial discrimination means eliminating all of it. You might be familiar with other versions of that statement from Roberts himself. He interprets this to mean that the government is applying one rule to someone based on their race and a different rule to somebody else based on their race. And that is how the majority in Roberts understands affirmative action, that it is a practice and policy that treats one race, race differently from another, and that people are favorably treated or disfavorably treated on the basis of their race with respect to education. And what he admits is very much a zero-sum context. So if you favor someone, you have to disfavor someone else. For those who are doctrinalists in the room, he turns then from that framework, from saying, look, this is what affirmative action really is. It's racialized treatment, to say, like, when in this case, even though this isn't the government, we're told, in the case of UNC, the government, in the case of Harvard, private education, what's interesting about this doctrinally is how the court blends both of those analyses. So for all intents and purposes, a private entity covered by Title VI treated the same way as a governmental entity covered, in this case, by the 14th Amendment. He then turns to the strict scrutiny analysis to say, when the government, or in this case, a private entity, treats people on the basis of race, then they have to satisfy the most searching form of inquiry and justification, which we define as strict scrutiny, and basically says there are only really two reasons why institutions and governmental entities can treat people, can use race as a basis for decision-making. So one of those includes where there is a riot in a prison. And of course, whatever you may think about the law school, and however riotous you might think it might be and oppressive it might be, I don't know that one could make a good faith argument that it is in fact a prison, and that these are the wardens. Right, so this is that's one context, is a prison. The other context is identifying and remedying an institution's past discrimination. So he said neither of those are relevant here, and that the government and that these institutions must have a compelling justification for the use of race, and argues that they don't have a compelling justification for the use of race. Now, if you're familiar with this area, you might say, what happened to the vaunted diversity rationale? That is, didn't we think that trying to achieve a diverse student body was a compelling justification that satisfied the limited use of race-based decision-making and the higher education context? That rationale seems to disappear magically from the court's opinion. The court uses the Grutter case to say, look, when you make race-based decisions, there are time limits. Grutter talked about essentially a 25-year framework, and Roberts says it has been 20 years and time is up. So the fundamental move then here is to say, we sanction the use of race in higher education for a limited period of time, Institutions of higher education did not do a good enough job of articulating what their goals are, when those goals would be met, and they rely upon crude racial stereotypes. So they define people as being white, Black, Asian, Native, etc. And these are all relatively crude racial stereotypes. Who really is what? We're not really sure, and they don't tell us how they come up with those categories. And there is no time limit. As a consequence, these programs must be struck down. So there's an abandonment of the previous approach and an ushering of a new regime. Okay, so let me close then by saying, obviously, this is I think there was an expectation that this is what would happen with affirmative action before this court. It was interesting to see how the court treated Title VI as opposed to the 14th Amendment, basically blending them together. The big question that I think most people probably had is that they knew what the outcome was going to be, but really, how was the court going to get there? And the way that the court got there was essentially to fundamentally really ignore the diversity rationale and to say that the institutions are not doing a really good job of explaining to us what diversity means, when are their goals being achieved, and to use Grutter's aspiration as a constitutional mandate. 5 quick questions that this case raises. First, there's been some debate as to whether the decision applies only to Harvard and UNC and not to affirmative action much more broadly in higher education. My best read is that I think it does, but that's a question that some are debating. Secondly, there's a debate as to whether the diversity rationale is truly gone, or is it that it wasn't compelling in this particular case related to the first question. Third, there's a question as to whether the court has announced a theory of equal protection that is applicable in all domains, or is it really limited to the higher educational context? Fourth, and relatedly, what is the Constitution's new conception of racial equality? We get a very formalistic decision here. And if you read Thomas's opinion very carefully, and he often predicts where conservative majorities are going to go, where he basically says race consciousness itself is inconsistent with the colorblindness ideal that is reflected in the Constitution. So if that is true, then the court is really beginning to announce a different framework of what equality means. But lastly, how should we think about the problem of structural inequality in a society stratified by race, by class, burdened by different types of histories? So you see an attempt by Sotomayor and Jackson to try to address that problem, but it is one that clearly the majority is uninterested in thinking about, but that is left to our broader society to try to think through and figure out. And having now posed those questions, I will leave it all to my esteemed co-panelists and experts to help us understand how human rights framework is going to resolve all of our problems. Thank you.
Thank you very much for giving us that beginning to the conversation. Professor McDougall, can I turn to you?
Yes, thank you very much. And Professor Newman, thank you for inviting me to join this conversation today. Guy, I'm very happy to meet you. Congratulations on your appointment to the chair and to lead the Charles Hamilton Houston Institute. Ogletree was a very close friend of myself and my husband, John Payton. So I can think of no better choice than you to continue the leadership role that he fashioned there at Harvard. And to my friend Tendai, who in a very short period of time has disrupted and restructured the discourse about the liberal human rights establishment. And of course, to my good friend Justin, who I see often, but not nearly enough. So I was invited by Professor Newman to talk about the UN's reaction to the SCOTUS decision, but particularly the reaction of the UN Committee Against Racism that I sit on, which I'll just refer to as CERD. CERD issued a statement in August about the decision, expressing a deep concern. That's, you know, as rough as we get, a deep concern about the decision, pointing out that it was counter to the international legal obligations that the U.S. has under the Convention Against Racism, which, of course, has been ratified by the U.S. The central argument that CERD has with the Roberts decision goes to the question of the definition of racial discrimination. What is it? What must be excluded from that definition? What measures are required to defeat it? What are the state obligations of the U.S. under international law? And I will sort of summarize our statement briefly, because there are two main points in the statement. First of all, about the definition. CERD's definition, and in fact, all of our work is rooted in the requirement of equality. Equality of outcomes, not solely equality on a procedural basis, but also fundamentally substantive equality. And it would be just going to one of your questions, Guy. We're looking for equality in the society as a whole. Discrimination under the convention includes purposeful or intentional discrimination and discrimination in effect, or what we call in the US, negative disparate impact, requiring no particular proof of malevolent intent. But the question also to focus on is the convention makes clear that differentiation of treatment will not constitute discrimination per se if the criteria of that differentiation is in concert, if you will, with the overall objectives and purpose of the convention, which is to create equality in the society. The term non-discrimination does not require uniform treatment when there are significant differences in the situation between one person or group and another. If there is an objective and reasonable justification for the differentiation, as in this case, it is not, it's not considered racial discrimination. That's in Article 1 of the convention. Secondly, when under the convention, when there is a situation of unjustified inequality falling along racial or ethnic grounds, states that are party to the convention are required, it is mandated that they adopt special measures or affirmative action. Special measures could be fashioned along legislative, executive, administrative, budgetary, or regulatory lines, or using those kinds of instruments, as well as through plans or policies, programs, or preferential regimes. the disparities that can be addressed through legitimate fashions of affirmative action programs can include both persistent or structural disparities, as well as de facto inequalities resulting from circumstances of history, as in our case, that continue to deny racial groups, an ability to enjoy human rights on an equal basis. So special measures are affirmative action, first of all, are not a part of the definition of racial discrimination. And secondly, are actually essential elements of the convention's project of eliminating racial discrimination and advancing equality. Now, there are some exceptions that need to be mentioned. You can't, well, the affirmative action programs must be, of course, for the sole purpose of correcting inequalities. It should be appropriate to the situation to be remedied, and respect principles of fairness and proportionality, which would mean also that they would be fashioned on the basis of disaggregated data, real-time data along racial lines. And finally, they have to be temporary, ending when a state of equality is reached and not established, and to not establish sort of permanent rights for one group as opposed to the other. So those are the restrictions, but the important point is that ultimately it is about creating equality, situations of equality. Secondly, affirmative action programs are not a part of the definition of racial discrimination. And thirdly, they are required under the convention and as a part of the US's obligations under international law. That is, I think, all there is to say about the statement issued by the CERD against the SCOTUS decision. But just to point out that, again, that the US has violated its obligations. You cannot regress. That's one principle that we have. So if you put in place a program of affirmative action that is working, unless there are good reasons for concluding that it is not being effective, it is a regression to do away with them. So as far as I'm concerned, that's it, I guess. I will turn it over to Tendaye.
Yes, please, Professor Achume.
Thanks so much, Professor Newman, and thanks to my co-panelists who I really wish I could be with in person. I'm setting a timer because I could talk about this topic for the next 5 days, and I think I only have 12 minutes. So it's a pleasure to follow after Gay's masterful account of how the decision we're discussing relates to international human rights law, particularly the International Convention for the Elimination of Racial Discrimination. And what I thought I would do is put CERD's jurisprudence on this topic in the broader context of the US's relationship to international human rights standards, past and present, as they relate to racial equality and racial justice, and also to say a few words about how this decision, I think, exists in a continuum with action that the US is taking on the global stage as well with respect to racial justice. I want to maybe begin by saying that some of the provisions that Gay was talking about, specifically the inclusion of special measures within the statement that special measures do not count as prohibited racial discrimination within the context of ICID, actually originated during the period when obviously the treaty was being drafted, and were coming from delegates, including formerly colonized delegates who were worried even at the time of decolonization that attempts to undo racial injustice, including structural racial injustice, would come under fire under the guise of reverse discrimination, or attempts to say that colorblindness was the only vision of racial equality. So at the drafting of the convention, this is something that delegates were talking about and were explicitly trying to head off at the time. And I raise this because you would think that at the moment when decolonization was, arguably at its peak, I'm thinking here of the 60s, even at that time, there were nations, especially colonial powers, and here I include the US, that were trying to advance a colorblind version of what equality could look like. And so if you think the concern now is enough time has passed, even at that point when you couldn't say enough time had passed, these kinds of concerns were being raised as well. On the historical point, I think it's also worth pointing out that the provisions around affirmative action make it into the treaty, the international treaty, in part because of advocacy by civil rights lawyers in the US, including civil rights lawyers who were actively involved in the drafting of the treaty. And here I recommend the work of Professor Tim Lovelace at Duke, who has some really interesting and helpful historical analysis on how, lawyers such as Clive Ferguson, who's understood to be one of the forefathers of affirmative action in the US, were active in the drafting of CERD and really working hard to see developments that were taking place during the Civil Rights Revolution also be reflected at the international level. So, one thing that is interesting when you think about the historical trajectory and the US's activities on the global stage, many of the US interventions that have been the most prominent, and I'll speak to a few of them in a moment, have been about undermining the strength of global standards around racial justice and equality, but they are these moments that are driven, in my mind, by domestic civil rights advocacy that also result in innovations at the global stage that reflect pushback within the US to racial subordination as well. So there's communication between the domestic and the international in really important ways. Before I say more about some of the stuff on the global stage, I do want to say that even though we're focusing on students for fair admissions, I think that Students for Fair Admissions feels like the nail in the coffin from the international perspective. And Gay, I don't know if you would agree, or Justin, if you would agree, but Baki, to my mind, was the mortal blow, because that's the decision that seems to take off the table societal discrimination, or remedying societal discrimination as a legitimate state interest that might be pursued in this context. And when you look at ICID, really it's about equality. By the time you get to Students for Fair Admissions and you're thinking about the diversity rationale and the kinds of measures that universities like Harvard and UNC have put in place, all of which to my mind are far better than nothing. So this is not to say that they are nothing. It's to say that when we look at those approaches, I don't see them as even coming close to meeting what the standard at the international level is, which is that affirmative action measures really should be about undoing societal discrimination, remedying historic and contemporary harm in a very substantive way that, to my mind, wouldn't be achieved by pursuing a diversity rationale. So I think the horses left the barn, so to speak. I don't even know if that's the right expression, quite a while ago. And it's incredibly depressing to see in the decision sort of what was left over, which feel like the crumbs in some way. So I was talking about how the US is, I would describe the US's approach to racial justice norms on the global stage as sort of ranging between hostility and neglect. So as far back as 1919, there was an effort to have a treaty that would regulate racial equality at the global level that was defeated in large part by the United States and its colonial and settler colonial allies. And the reasons for the opposition in 1919, to my mind, were anchored in the foundations of this nation, the US as a white settler colonial nation and an imperial hegemon. So that in 1919, that attempt is defeated. I mentioned a little bit about how by the time you get to 1960s, when CERD is being negotiated, there's been a shift within the United Nations that means that formerly colonized nations are a critical mass that results in the passage of that treaty. And at that time, the US is in a position of trying to exert influence over it. And this is when we see the work of civil rights advocates actually shaping the content of the convention in ways that I think are exciting. And as I mentioned, are covered in Tim Lovelace's work. I would say that it's worth noting that the problems with the US's relationship to the international treaty go far beyond the affirmative action debate. And as Gay was mentioning, there's some fundamental questions about how racial discrimination is defined in the domestic context that are just deeply at odds with what's happening in the international convention. CERD was adopted in 1965. It wasn't until 1994, almost 30 years later, that the US would actually ratify that treaty. And that's different from many other countries who ratified the treaty earlier. And when the US ratified CERD, it did so with a host of reservations that really blunt the effectiveness of that instrument domestically. So it has a reservation that says that ICERD isn't going to be self-executing in the US. The US has failed to enact implementing legislation that would actually make it so that people in the United States could go to court and seek enforcement of provisions of that treaty. The US doesn't permit US citizens to take individual complaints against the US to the Committee for the Elimination of Racial Discrimination. That's the treaty body that monitors the treaty, and other nations have given that permission. And so there's all of these ways in which the US has blocked and continues to block the effectiveness of international standards that are really far ahead, I think, of what the domestic framework for racial equality has evolved to become. And it's worth noting that this opposition, hostility, neglect, however you want to describe it, has existed across administration. So this isn't a problem of a conservative court or a conservative US executive. Democratic and Republican administrations, I would say, have participated in erecting these barriers to international instruments having effect domestically. And as Ian Kissel and Alex Sinha note in a really interesting article they published recently on just security, on the affirmative action decision, and also on measures that the Biden administration could take to implement CERD through executive action. I recommend that to anybody who's thinking about where do we go from here. I recommend that post on just security. But they note that the Biden administration's amicus brief in Students for Fair Admissions didn't mention ICERD at all. It didn't mention the special measures obligation. So even the Biden administration isn't raising international human rights law in the context of the litigation. It hasn't really mentioned it in its response. And you might think that that's a strategic move. Politically, it's perhaps not the wisest to be invoking international law in the US context right now. But I would argue that the political context is also tied to a legal context that pushes a kind of US exceptionalism that is bipartisan, and that I think is also really rife in the legal profession as well. There's a dismissiveness of international human rights law that can't be separated, I don't think, from what we're seeing. When I took constitutional law, and Guy, maybe your class is different, when we studied the Equal Protection Clause, when we studied the 14th Amendment, you wouldn't have known that there was international law that was relevant to any of the issues that are associated with that. So I think there's a deeper cultural and political and even economic structural reason for why there is this gap between what the US does and the standards that exist at the international level, which the US is involved in setting up, but then exempts itself from having to comply with. A few other points, I would say that, and on this point, I think the work of Aziz Rana is really interesting. As Aziz Rana's book, which talks about how the failure even of kind of US constitutional lawyers and US constitutional culture to grapple with the US as a settler colonial nation manifests in the way that the jurisprudence evolves and is understood and critiqued, I think is also relevant for thinking about the international stage as well. The final thing I'll say is, I think what's troubling to me is what's happening in the US doesn't just stay in the US. And in Q&A, I'm happy to talk about the ways in which US jurisprudence and colorblindness as a doctrine travels internationally, including to say regions like Southern Africa, and then has afterlives that shape the way that racial equality is conceived in other areas. I think there's a problem there. But I think also we should think about the conversation we're having in relation to some of the work that the US is doing at the global level to undermine processes of taking seriously reparations for colonialism and slavery that are being pushed within the global system as well. So we've been talking a lot about the International Convention for the Elimination of Racial Discrimination, but I want to name the Durban Declaration and Program of Action, which was adopted in 2001. And is a product of the largest and most comprehensive transnational mobilization to address systemic racial injustice, and kind of, was agreed to by the UN, insists on the urgency of reparations for colonialism and slavery, of which affirmative action, I think, are a central part. And you see the US consistently boycotting and undermining the DDPA, again, across administration. So this isn't a kind of left-right issue. This is a kind of US position. And you see US opposition to resolutions in the Human Rights Council that are about taking concrete action to address racial injustice as a transnational issue. And that continued action to undermine racial justice, even within the global regime, I think has to be connected to some of the dynamics that are kind of sometimes framed as purely being about a particular Supreme Court or about a particular US administration as well. So I think I'll conclude by saying that the US's global stance on racial justice and even the way that US constitutional jurisprudence around racial justice and its relationship to human rights in the international framework has evolved really can't be divorced from the US's status as a settler colonial imperial hegemon whose nationhood in some ways has been secured and institutionalized through racial subordination. And until we untangle that core, or untangling that core, to my mind, is a critical part of understanding what next steps might look like. I'll stop there.
Thank you. Thank you. Professor Hansford?
Great. All right, good afternoon. Hard to follow that wonderful presentation, but I'm going to start out by mentioning that I want to give a quick description of my view of this decision as a critical race theorist, as a movement lawyer, as a human rights lawyer, but firstly, as an alumnus of Howard University and a law professor at Howard University. I still think it's the greatest historically Black college or university in the country. Some people try to dispute that at times, but they're wrong. Founded in 1867 as part of Reconstruction. Many of you know that it's the alma mater of Thurgood Marshall, Kamala Harris. Some also may note that most recently it was the site of something called the Blackburn Takeover. In October of 2021, 150 students erected a tent city in the student lounge, Blackburn Lounge, to protest rats, roaches, and untreated mold in the dorm rooms. There was an outcry amidst allegations of financial mismanagement or the failure of alumni to donate sufficient funds for upkeep of the dorms. but it's come to our attention over the last couple of years that perhaps financial mismanagement wasn't the major factor. Last week, the Biden administration sent letters to the governors of 16 states appealing to them to invest more money in HBCUs on the grounds that $13 billion that HBCUs should have received over the last few years, in particular the last 3 decades, was never received. That's a $13 billion gap. These states include Florida, Alabama, Maryland, Kentucky. Kentucky is particularly interesting. It was noted in my research that during the middle of this century, it was found that Kentucky invested 42 times as much public funds in its predominantly white universities as its HBCUs. And Maryland's interesting because my own Thurgood Marshall Civil Rights Center was part of a lawsuit which resulted in a $500 million settlement on the basis that the University of Maryland was receiving systematically disproportionately high amounts of public funds, and Coppin State and Morgan State and other HBCUs in Maryland were underfunded. So we received $600,000 in attorney's fees. I mentioned all of this because before I begin to discuss international law, I want us to discuss the question of educational equity and equity in terms of race in the field of education, not only as a question of access, but also a question of resources. Indeed, when the affirmative action process began in the 1960s under President Kennedy's administration and President Johnson's administration, it was initially framed as a remedial process, providing a remedy for past harms. It was the Bakke decision, as described earlier, that decided to transition from a position of remedy or the provision of economic justice, but the provision of access to institutions of higher education, and to transition to the rationale to a educational theory that was arguing that diversity was a more effective approach for educational success. So the shift from the remedial rationale to the educational theory rationale, as Tendai mentioned earlier, was in many ways the death knell for the process of providing meaningful repair through affirmative action. And I'd love to, not just as a quick response to Tendai, I'd love to talk more, and also Gay, about the way that some of these very instruments that we engage with, such as CERD and other non-discrimination, color blindness in some sense, based instruments in terms of their language, were impacted by the Bakke decision and the discussions that were happening during that time. But even in spite of this framing of educational equity in terms of access to elite institutions, it's still the case that today, according to the White House, 50% of all Black lawyers in America have attended HBCUs, 40% of Black engineers, 80% of Black judges, 70% of Black doctors. And this is happening during a time when the median endowment for HBCUs is $138 million, while Harvard's endowment, you guys may already know this figure, it's quite large, $50 billion. So that gap of 138 million to 50 billion has to be understood as the core of the argument that educational equity has been denied in the United States in light of not just the affirmative action decision, but a history of actions that took place over the course of the 20th century. Now, the grounds for that, as Guy so expertly discussed, are very thoroughly described in the most recent opinion. I do believe one of the things that was overlooked was the transition from affirmative action being, again, a remedial process that sought to overturn segregation in the United States into a process that sought to overturn race consciousness. Now, in the process of the international human rights sphere, we have a number of possibilities that could help us to further understand what has taken place in the United States when it comes to educational inequity. And in addition to the tools and mechanisms that were mentioned earlier, I am part of the United Nations Permanent Forum on People of African Descent. One of our mandates is to implement the International Decade for People of African Descent. Now, raise your hand if you've ever heard of the International Decade for People of African Descent. I'm pretty surprised that's four out of the entire room, right? So this is a mechanism that has been woefully underused. The decade began in 2014. It's ending next year in 2024. But understanding the failure to reach the goals of the decade, which include educational equity, which includes language around providing not the same amount of access, but more access to higher education for people of African descent in light of the harms that took place over the course of the 20th century, in particular segregation. This is just an example of what Tendai was mentioning, the failure of international human rights law, not only to be implemented, but to even be cited in Supreme Court opinions, but also in the policy prescriptions of the executive branch and other parts of our legal infrastructure. So as part of my mandate, we also call for the collection of disaggregated data on the advancement of people of African descent, in particular data that would move us closer to the accomplishment of the Sustainable Development Goals that the UN has set out to have been met by 2030. There was a great deal of talk about this last week at the UN General Assembly. But you'll find that if you were to look for disaggregated data on the progress of African American students in higher education, even the collection of data is far behind, woefully behind what it would be necessary to give an effective, comprehensive score to the United States on how well it's improving in terms of access to higher education. So taking a step back, so we described that there are measurements and aspirations that have been set out by the International Decade for People of African Descent that are not often mentioned or cited, let alone pursued. There is even a failure to accumulate sufficient data that is disaggregated so that we can measure our progress towards meeting these Sustainable Development Goals, which have been so highly touted on the world stage. So if this process of using affirmative action to provide some sort of remedy was still a commitment in the United States, or to provide some access to economic justice was still a commitment in the United States, if we were going to still adhere to those broader goals, we still want to try to make this a more just society, what would we pursue? What would we pursue? And I do want to also continue to insist that the move towards a reparatory justice lens is perhaps the only effective avenue that remains with the demise of affirmative action. So thinking about reparations as justice for not just individualized harms of enslavement, but also segregation, in particular segregation in higher education, could lead us to a more thorough analysis of what it would take to really reach educational equity. Going back to my beginning statement, thinking about investment in HBCUs as a remedial measure that could bridge the educational equity gap, that could provide more access to economic justice in the absence of any sort of affirmative action. So now I'm putting on my movement lawyer cap. So as a movement lawyer, we're always trying to think about pragmatic activities that you could use to try to obtain goals that are driven by social movements. So if you're part of the movement for educational equity, what should you do today using the global lens to try to determine how you can use whatever tools are at your disposal to promote more economic justice and educational equity in the United States? In 2019, I was able to work with the Inter-American Commission on Human Rights to put together a thematic hearing on reparations. At that hearing, we were able to gather testimony as to the proper grounds for reparations as a society. We were able to take some of those pieces of testimony and worked with an organization called the Movement for Black Lives to put together a Reparations Now toolkit. That toolkit has been used by local commissions all around the country. About 2 months ago, students at Howard University did some research and found that there are 40 local reparations commissions that have sprouted up in the United States since 2019. I would like to say it's all thanks to our committee hearing, but certainly more credit should go to the George Floyd protests and the energy that was created during that time period. But this type of interaction between the creation of a record on the international stage through the use of these mechanisms and trying to find tools that can get that information out to local activists is in all likelihood the most effective method that I can see for us to move forward in the fight for educational equity in 2023. Another objective that is going to be something I pursue this year is creating a bar association, a reparations-based bar association, actually thinking of calling it the Ogletree-Robinson Bar Association after Randall Robinson, who drafted a number of important documents, and most importantly on this issue, The Debt, the book that he wrote in 2001, which I recommend to all of you on the question of reparations, called The Debt. And of course, Professor Ogletree, who worked with the Tulsa, Oklahoma survivors in that campaign for reparations. But with this bar association, we're seeking to support movements not only on the city level or municipal level, but also working with universities, working with companies, working with those who are seeking to file lawsuits on the family level, to try to provide more opportunities for reparatory justice to be promoted as a legitimate avenue in American society and global society as well. This was actually a hot topic last week at the UN General Assembly. We know that Prime Minister of Barbados, Mia Mottley, has called for something called debt justice, which she would have to focus on climate justice in particular, involving countries in the Caribbean. We also know that the president of Ghana has also called for reparatory justice as a legitimate tool for change. So all of these tools are happening on the global level. We know that traditionally the human rights lens, these human rights mechanisms, whether it's the UN Decade for People of African Descent, whether it is the Inter-American Commission for Human Rights, whether it is CERD, the Commission to End Racial Discrimination, all of these tools are going to be much more rich, much more aggressive on the question of racial justice than the US Constitution. So for me, if we're going to move the ball forward as advocates, we have to use the most aggressive tools at our disposal. And so as a movement lawyer and as a human rights lawyer, I believe that applying those tools locally, supporting activists who are trying to make change on the state level and on the level of universities and companies and other different mechanisms is perhaps the best way to move forward to achieve true educational equity in the 21st century, because ultimately it will depend on us to make sure that we move from affirmative action to reparations. So thank you.
Thank you, Professor Hansford, and thank you to all the panelists who have spoken. I promised you there would be a time for questions from the floor, and I am going to invite those questions in a moment. Before I do that, I would like to just make a couple of comments of my own. One comment is, when we deal with the role of human rights in oppressive societies that don't take their international obligations seriously, political scientists tell us that one of the most important roles that human rights treaties serve is to validate the concerns of the people and the NGOs within those societies, to motivate and even to give some protection for them in their work within the local politics in which things need to change. That may be true on this subject in the United States. I also would like to say I view the Bakke decision, which Professor Achume mentioned, somewhat differently, perhaps, in relation to the recent last nail in the coffin. I don't think that the mortal blow had to be as mortal as it has now become. And in that connection, I want to point out that when the United States ratified the CERD Convention in 1994, it put in a number of reservations that watered down its obligations, but it actually did not do anything to water down its obligations with regard to affirmative action. One could ask why that was. There are various historical possibilities, but one element of that is that the Supreme Court's understanding of the remedial powers of Congress at that time was more protective than it currently is. So the Supreme Court may have changed US constitutional law this year, and it may be the Supreme Court's prerogative to change US constitutional law next year, but that doesn't affect the fact that the Supreme Court may be changing US constitutional law in a manner which is inconsistent with the obligations that the United States voluntarily took on when it ratified CERD in the precise manner in which the United States ratified CERD. So after those comments, I'd like to take questions from the floor. We have one question in the back there.
Thank you. So having read the decisions, there seems, and having attended several of these sort of aftermath conversations, there seems to be a discomfort with really wrestling with the origins of civil rights law on this issue and the path forward as far as a commitment to this idea of reparations. The turning away from reparations, the turning away from making reparations for past harms was not foreclosed upon by the decision. And I guess the Kavanaugh's part of the opinion very much made it clear that the historical linkage to lineage, the historical linkage to America paying its debt to the harms to the specific groups of people it harmed is still on the table. What we know about affirmative action and how it has played out is that going for an objective where we can create an optic diversity without by also leaving behind the main group that fought for the equality, that fought for the Civil Rights Act. And I'm speaking about Black Americans who descend from slavery, who have been in this country and have benefited the least from the implementation portion of these provisions. I don't frequently hear what movement lawyers are going to do about returning to lineage and returning to focus on not how we should get everyone who is not white into schools, but how we should remain committed to the unpaid debt. So I do also want to note that yes, there is a burgeoning conversation about reparations. The starting of local reparations commission has been fraught with problems due to the lack of a core mandate and the lack of funding at a state or local level, which will not be remedied by a piecemeal strategy. When we're talking about reparations and when we're looking at how civil rights activism actually played out, the national question is not off, it should not be off the table. The question of national organizing for federal policy changes should be at the core of this. I guess I just want to say, like, it feels like there's a lot of power grabbing and money on the table when we talk about starting your local reparations commission and getting paid to be the commissioner and to sit around and produce reports, like in the case of the California Reparations Commission or the Illinois Reparations Commission, that have made a lot of promises and have come up against the core question of what are you going to do for the descendants of slavery. We're not there yet. We don't even have a cogent strategy about how to move forward from SFFA. And that lack of cogency feels like it's an academic opposition to actually addressing Black Americans.
Thank you.
Yeah.
If I can give the panelists an opportunity to respond, I first want to say I know it's harder for the remote panelists to make their desire to respond known. I see Professor Achume on the screen. Professor Achume, is there anything you'd like to say in response to that before I give the word to the people who are sitting next to me?
Sure, and I think a lot of that question is probably best handled by Justin, but I did want to say two things. One is that even on the very meaning of what reparations is, I think the International Human Rights Framework has a lot that is helpful and enriching about that conversation. And I think the person who spoke is right, that I don't think the SFFA decision forecloses entirely the question of reparations for historical injustice. But I do think that the discussions around reparations have to also engage with how reparations are about contemporary structures of subordination that are initiated in the past, but have impacts today that are structural and that may not result in us being able to identify individuals who were necessarily kind of harmed by a specific policy in the past, right? So I'm happy to recommend the report that I wrote on reparations that is trying to say we have to be forward-looking and backward-looking if we're thinking about international human rights law and what it says about what reparations require. The threat I see from the jurisprudence in the US is to argue that race-conscious remedies that are structural are problematic because of some of the effects that they may have on individuals in the present who weren't necessarily involved in the harms that were initiated in the past. We could talk more about that. I think we need a comprehensive conception of reparations. Some of that is untouched but by the decision now, but there is a lot that I think that can be removed depending on how it's read. And, you know, Jerry, I did want to respond to something that you said. I think you're right that I am quite bleak in my assessment of the US, and there's a way in which I really feel as though even at the time of ratification, you're right, affirmative action isn't addressed by the reservations, but you know, the declaration that says that the treaty is non-self-executing, and then you combine that with no implementing legislation, there's moves that are made at that moment that are not as bad as some of the moves that we see today, but that to my mind still speak to a lack of commitment that I think is worth taking seriously and might be a pressure point for advocates today who want to think about ways that an administration like the Biden administration, which says it wants to take racial justice seriously, could kind of be put under pressure as a result of some of the ways that it behaves in relation to international human rights law. So just two quick thoughts.
Yeah, maybe can I make two or three quick responses?
Yes, and it's
as
great,
well.
it's great that you've come on the screen because I didn't know how we were going to do that.
I don't know. But look, I mean, first of all, to the questioner, let me just say that as far as CERD is concerned, affirmative action is something that it stands on its own. Reparations are separate. So, you know, I mean, we don't like this sort of continuum in the discussion between affirmative action and reparations. They're based on two different things and two different sets of principles. And we've got to fight for both. You know, the question about the local politics that are now beclouding, I guess, the movement forward on reparations commissions, et cetera, at the local level is something I think that we can refer to Justin. But I will say this. I think that it's very important to recognize that the United States has, from the beginning, instrumentalized the issue of racial justice internationally, largely for its own benefit. You could go back to the Brown versus Board decision that demonstrates that. But it also has instrumentalized the United Nations, and how it has reacted to the whole discourse and the architecture around human rights. The US position has always been that it will only ratify a treaty, a human rights treaty, if it feels, number one, that it already has complied with it. It's not going to use it as a basis for setting goals for the future. And secondly, that this array of reservations, understandings, and forget what the declarations are to sort of put us a stake in the ground that says these are not going to apply to the people in the United States. Now, on the global level, we say, well, that's very interesting, but actually, once you ratify these treaties, there are a certain set of rules that apply, whether you like it or not. And so that we will continue at the global level in terms of how we try to press for implementation of international treaties. We're going to overlook some of the reservations that governments like the U.S. have made. You can't say on the one hand that you ratify a treaty and on the other hand say that it doesn't apply, which is what has been the effort that the U.S. has made on this ground. I will say that we face Justin, a crucial question. Yes, Professor Newman, these treaties and the architecture that they have established give a doorway for local NGOs and victims to come forward and to plead their cases on a global stage and to say things to their government officials that they are not ordinarily able to say. And to do that often through the members of the committees, who raise questions with a different level of legitimacy to the governments. But we face a problem in that governments are not complying, they're not implementing. And this is being led by the United States. And so it's just shooting a hole into any claims of a viability of the whole system. So, eventually the NGOs and the victims say, well, hell, why do we have to come? This whole process is not getting us to the next stage in terms of realizing our rights. It is a very crucial question that we're facing right now. And these questions are being asked by the NGOs, by the victims, et cetera, and the answers are not on the table for us. But the worst of it is that the US is leading in this whole, approach of overlooking their obligations. So I will leave it there, but at least I thought those things were worth saying.
Thank you, Professor McDougall. I would like to thank all of the panelists before I give the last word to Professor Hansford.
Oh. right. Well, thank you.
It can be 2 words if that's all you want.
I want to thank everybody for coming this afternoon. Really briefly, I just wanted to say that we created an organization called the African American Redress Network that anyone online can look up, AARN, African American Redress Network. It's designed to support local reparations campaigns around the country using legal tools as well as research tools. And it's still my contention that, as the guest stated, that not just Kavanaugh's opinion, but the public opinion at the time is allowing for more space for discussion of reparations than any time in American history. In part, that's because of the demise of affirmative action, not just legally, but also pragmatically as a tool for fundamental restructuring of racial inequality in American society. And with the acknowledgement that that was insufficient, now perhaps illegal, other tools are rising to the fore. And I hope this is one that people continue to explore, because I do believe it has promise. So thank you for coming out, and please stay in touch. All right.